left at a point in time to go and see the petitioner. Is that so?
That is correct, my Lord.
You have also admitted that you signed most of the summary sheets, the original summary sheets, 13 of them, out of 16.
That is correct.
Good. Now, did you sign these summary sheets before you left to see the petitioner?
Yes, I did sign the 13th before going to see the petitioner.
Okay, thank you.
Can the witness be discharged, Your Lordship? By court, PW3 is discharged as a witness.
Most grateful. That is the end of our case.
Okay. The case for the petitioner is closed. Yes, Mr. Aminuvo.
My Lord, with respect, it's our submission that in view of the evidence led by the witnesses of the petitioner and our cross-examination so far, speaking for the first respondent, I'm of the view that there is sufficient evidence before the court for this petition to be determined. And therefore, my Lord, yes, Lord, I was saying that given the evidence of the petitioner's witnesses and the cross-examination so far, of those witnesses, my Lord, speaking for the first respondent. Yes, my Lord, it is the first respondent's case that we do not wish to lead any further evidence, and therefore we are praying that this matter proceeds under Order 36, Rule 4.3 and CI 87 Rule 3E5, and we hereby, on that basis, close our case. That is so.
Mr. Menuvo,
Yes, my lord.
what then happens to your witness statement?
Well, my lord, under CI,
You file a witness statement.
yes, my lord.
And the witness statement is supposed to be subjected, it is going to stand as your evidence in chief.
Yes, my lord.
And therefore, it's supposed to be subjected to cross-examination.
Yes. My lord, under CI 87 Road 3E5, where if a party who has served a witness statement does not call the witness to give evidence at the trial or put a witness statement in as hearsay evidence, any other party may put that witness statement in as hearsay evidence. So, my lord, we are saying that we are not calling any further witness. If the court decides to treat our witness statement as hearsay evidence, well, the court is entitled to, but we are not needing any further evidence. We are not calling evidence.
The rules say the court can treat it as hearsay. So any party.
No, the party, a party, not the court. Sorry.
Not the court. Yeah.
The other side can treat it as such. Thank you.
My Lord, respectfully, we need to understand the nature of what is being put forward clearly.
In a nutshell, it is our submission that given the evidence from the petitioner to a petitioner's witnesses and the court examination so far, speaking for the first respondent, we do not wish to leave any evidence. We submit that we are not calling any evidence and close our case. Then he refers to Order 36.
Order. You refer to Order 36.
My Lord, Order 36 Rule 4.3, with your kind permission, if I may read. Where the defendant elect of CI 47, my Lord. Where the defendant elects not to adduce evidence, then whether or not the defendant has in the course of cross-examination of a witness for the plaintiff or otherwise put in a document, the plaintiff may, after the evidence on behalf of the plaintiff has been given, close the plaintiff's case, and the defendant may then state the case for the defendant.
Respectfully,
Yes, my Lord, CI 87 on what will happen to the witness statement if you choose not to enter the box, my Lord. Rule 3, that's sub 3E sub 5.
it is our respectful submission that counsel for the first respondent does not have it open to him to take the cause that he just proposed to this court. Order 36 Rule 4.3 that he refers to specifically says where the defendant elects not to adduce evidence. In these proceedings, the defendant has put in a witness statement. So, my Lord, I'm sorry.
Yes, evidence. It is just a statement.
My Lord, what this provision says, where they elect not to adduce evidence. And what I'm saying is that the election that they made to submit the witness statement to the court is a clear indication that they made an election to the contrary. Because, my Lord, in these proceedings, at the point of case management, your Lordship basically asked questions from all the parties as regards witnesses being called. And it is at the point of case management where such an election is notified to the court. At that point, they elected to submit a witness statement. Now, that witness statement is not yet in evidence. That is true. But this is referring to an election. The point of election came at the point of the case management. And we are respectfully submitting that this witness cannot run away from cross-examination when they have elected. My Lord, when they have elected, that is the point. They have elected to please. Oh, my Lord,
maybe you can
my Lord, but run away, my Lord, respectfully, yes.
A telecasting. People may interpret it.
I will adopt your words. If your Lordship,
he's evading.
My Lord, I will totally adopt your Lordship. I will totally.
Yeah, please, you have the opportunity to. Yes.
Yes. Assuming we were not dealing with witness statements.
I'm sorry.
Assuming we were not dealing with witness statements, and we're giving oral viva voce evidence, when would you say that a party has elected not to give evidence? Assuming we are not using witness statements.
At the case management stage. If the party at the case management... My Lord, at the case management stage, the party may... No, otherwise the case management stage is meaningless.
No. If a party is called upon to testify, and then he tells the court, I do not intend to testify, that is when we say that the party is not willing to adduce evidence.
My Lord, respectfully, that is not the situation under the rules as amended to provide for case management.
This stage is proceedings at trial. So we have moved into trial stage. Order 36.
Yes.
Deals with proceedings at trial.
I appreciate that. And the point I'm making is that Order 36 is premised on where the defendant elects not to adduce evidence. So, my lords, what I'm saying respectfully is that in the context of the CI 47 obviously precedes CI 87. And in the context of CI 87 and the provisions for case management, the case management context is a context in which, for the purpose of a trial, the judge asks the parties how they are going to proceed. That's what I understand case management. Your lordships have had many occasions to point out the significance of the case management process. And my respectful submission is that it is in that case management process where, one, the party gives an indication to the court that I intend to call these witnesses. Now, if the party gives that indication, then respectfully, the party has made an election to adduce evidence. And my lord, that is the basis on which the court made orders at the stage of case management as to when witness statements should be put in. The court made orders on the basis of the election that they had.
No, that's a point of correction. The orders for witness statements is made at the application for direction stage and not at the case management. The order is made on the order 32. Yeah, the application for direction stage.
But my lord, that is the situation here is different from the pure high court situation, because in this case, at the case management stage, in this situation, we did not have a direct application for directions, my lord. We did not have that. I believe that's common ground between us. So in this case, we move to the case management stage. And in the case management stage, the court makes orders on the basis of representations that are made to the court by the parties. And respectfully, the representation that was made to the court at that stage is that we are going to call a witness, and we will provide a witness statement on behalf of that witness. That's the clear indication that they gave. Otherwise, the court would not have made an order, submit your witness statement by such and such a date. That is very clear, my lord.
I want to come in, Mr. Chikata. Now, are you saying that if you decide to call 5 or 6 witnesses and you put in 5 or 6 witness statements, you cannot at any point in time tell the court that though you have put in 6 witness statements, you are not going to call all the 6. Can't you say that?
My lord, you can say that.
Yes, please.
My lord, you can say that, but that is not what is dealt with in Order 36.3, which is what they're coming on.
You see, under the normal civil procedure, if the prosecution closes its case, and that's maybe the plaintiffs, that's what I'm using prosecution in the civil sense, for the plaintiffs.
My lord, with the greatest respect, yes, let's just stick to what we're familiar with. If you say prosecution in the civil...
Okay, so if the plaintiff closes his case, and the defendant realizes that the case the plaintiff has made has no substance, or does not establish the release he is claiming, and there will be no need for him to testify, he can tell the court that he will not testify. And then he will be put to his election. Whether if the court rules in respect of his application, he will still testify or he will not testify.
My lord,
that is the procedure.
My lord, with the greatest respect, that is not the procedure under our rules. With the greatest respect, that procedure may apply under the English civil procedure rules, but it does not apply under our rules. And with the greatest respect, if I'm wrong in that, I will stand to be corrected. Which rule under our rules has that provision?
It's a settled practice.
My lord,
so are you saying that, my lord, the party cannot say that I will not testify, judge the case according to the evidence you have?
My lord,
because you cannot compare anybody to testify.
My lord, with the greatest respect, my lord, with the greatest
order in court, please.
With the greatest respect, I wish to take it a step at a time. If your lordship is referring to a submission of no case at the end of testimony, if that's what your lordship is adverting to, my respectful submission is that, one, under English common law, it is in fact not available in a trial which is not before the jury. Under common law, the authorities are clear that process that your lordship just described is not available. And I am prepared to cite some authorities in the common law which make that clear, including a well-known case of Alexander and Racing. But, my lord, before coming to that, I just wish to clarify that the common law position is very clear. Where there is a jury, it is open under the common law. Where there is a jury, it is open for Where there's a jury, it is open for the plaintiff to say indeed that I don't want the matter to go before the jury. I'm ending at the point of the trial judge. But the common law position that has been clearly stated in the English Court of Appeal is that where there is only a judge and not a jury, that procedure is unacceptable. And there's a very clear reason given for it in the authorities, which I'll come to. But my Lord, I want to...
I want to understand something. Are you suggesting that a party can be compelled to give evidence?
My Lord, that is not what I'm suggesting. I'm just suggesting that Order 36, Rule 3, applies in terms of the precondition that is put there. In terms of the precondition, it says where the defendant elects not to adduce evidence, then whether or not the defendant, and I'm saying respectfully that in this case, the first respondent elected to give evidence and notify the court as such. The first defendant elected to give evidence, notify the court as such, and on that basis, the court made an order for a witness statement to be provided.
Mr. Chikasa, you are aware that at case management stage, nobody knows the evidence that the other is. It is after case management audit that the testimonies come in. Is that not it?
Very clear. I mean that's a matter of chronological necessity because, that is a chronological necessity. A case management happens before witnesses are called to testify, so there can't be any doubt about that. I'm referring to the fact that under Order 36.3, which counsel for the first defendant is seeking to come under. And my Lord, this is also different from the submission of no case under the common law.
Excuse me. Order 36 for subrules 2 and 3 together. It says, subject to subrules, the plaintiff shall begin by opening the plaintiff's case. Then 2, where the defendant elects not to adduce 3, where the defendant elects not to adduce evidence. It presupposes that the plaintiff has finished his case. That is my understanding. I stand to correct it.
My Lord, respectfully, that cannot be the case. Because my Lord, Order 36.4.3, and respectfully, as I said, those rules predated CI 87 on case management. CI 87 introduces case management on the basis of which your lordships have proceeded and given orders. And respectfully, I'm submitting that under the terms of CI 47, Order 36, Rule 3, where the defendant elects not to adduce evidence is a precondition for that. And in this case, the defendant, as the case management stage, represented that they would adduce evidence, and therefore that precondition does not exist. And the defendant made those representations to the court and to the court in a manner which led your lordship to determine.
Mr. Chikasa, may I seek clarification?
Yes, my Lord.
Are you suggesting that under the case management regime, a defendant who indicates to the court before evidence is taken that I will call 1 or 2 witnesses in this matter, then after the plaintiff has given evidence, the defendant says, I don't think I need to call any evidence. Determine the matter on the basis of what the plaintiff has brought.
cannot do so?
Yes, my Lord, I'm saying that he cannot do so where the court, on the basis of their representation, has ordered witness statements to be submitted. Because where he does that, he has elected other than what is provided for in Order 3643. Where he makes that election at the case management stage, and the court has made an order appropriately.
The Order 36 Rule 4 is only regulating order of speeches.
My Lord, I didn't quite.
Order 36 Rule 4.
Yes, that's the next.
Only regulating the order of speeches. That's all that the rule is seeking to do. But
yes, but my Lord,
how can the law say that a party compel a party to give evidence by all means?
No, my Lord, respectfully, if you say that the order of speeches is all that.
Yes, order of speeches.
Yes. My Lord, that's a head note. Yes. And your Lordship knows very well that the head note does not settle the interpretation of the provisions. I mean, Bernard Mona's case is a classic instance where the head note was shown to be completely different. And in fact, if we were only dealing with order of speeches, then my learned friend is completely out of court, because if that provision is only to do with order of speeches, then he cannot, on the basis of that, be asking your lordships to do or be telling the court what he told the court. If it's just order of speeches, then it will be interpreted as such. So it cannot be just order of speeches.
These proceedings are.
I'm sorry.
Order 36. These proceedings are tracked.
Yes, but Order 36(4), as his lordship pointed out, is order of speeches. That's what your lordship pointed out to me, and I agree. It says order of speeches. And I'm saying that the head note cannot limit the terms of that order, respectfully, because in fact, if your position were to be accepted, respectfully, then you should throw him out of court completely, because we are not yet at the point of order of speeches. We are not yet at that point. So if all that 36 Rule 4(3) is dealing with is order of speeches, then all he said is irrelevant, because we are not yet at order of speeches. But the reality of the matter is that head note cannot limit the terms of Order 36 Rule 3.
Mr. Chief Justice, isn't compelling someone to testify a human rights question?
Also, my Lord, I'm sorry. My Lord, this is new territory. I mean, I have to think of it. Because
nobody can compel a party to testify.
My Lord, frankly, I have to give considerable thought. In fact, I have to give considerable thought to what you're saying. That you're not.
As I'm sitting here, I'm reviewing this whole thing.
Yes.
I mean, nobody can compel a party to testify.
My Lord,
that's a very basic rule.
My lady, as I said, I mean, your ladyship has been part of a ruling in this court which said the right to vote is part of the directive principles of
Chief Justice, please, may I have your attention?
Yes.
Please, none of us, at least those on the bench, none of us anticipated this step. So please both of you come and address us on this point tomorrow. Then you will give a ruling on it and then proceed accordingly.
My Lord, I was actually going to make a similar submission, because it is my respectful submission that for an application of this nature under Order 19, it should be made in terms of a motion paper and a supporting affidavit, so that we can respond appropriately. Because, my Lord, that application that is being made...
Please, with all respect, please, there's nothing factual about this application. Yes. Let's take it. If he comes tomorrow to raised this legal issue, you have the opportunity to reply. So please just prepare.
Very well.
And bear with us tomorrow.
Very well. Very well.
Yes. Please, we want to know your position because you have also filed a witness statement.
My Lord, we do not intend to call any witness.
Okay, then you prepare.
And my Lord, let me complete.
Order.
We do not intend to call any witness because in our view, they have not satisfied the burden of proof. So we can't be forced to call any witness.
We don't want lengthy answers. Please, what we want you to do is to prepare, come and address us on it tomorrow. Then we will give a reasoned ruling on it and proceed accordingly. Thank you very much. Please, you will rise for the day.